how can that interpretation ever be accepted by a constitutional court? Means that you don't need consultation, you don't need concurrence. You can unilaterally do it. For everything else, you'll need that. That's a constitutional absurdity. For individual articles, you have to concur, but for the whole abrogation, you don't have to concur. Bilateralism is at the heart of the mechanism provided by Article 370, in terms of which laws applicable in the Union of India through the Constitution of India as applicable to Jammu and Kashmir are to be applied. It is this bilateral process which allows for a process of integration that is constitutionally envisaged in Article 370 of the Constitution. And any adjustment of the relations between Jammu and Kashmir and the Union must follow this bilateral process. And last of all, even with respect to 368 of the Constitution, the process of exercise of constituent power resulting in amendment of the Constitution is also given effect through a bilateral process. Bilateralism is at the heart of the said process because you have to consult at least get agreements of at least half the members of the states. That too is a bilateral process. Nothing can happen outside there can't be a unilateral act of an executive, not even parliament. Consider this, Malas, what we're talking about, a unilateral act of the president acting on the aid and advice of Council of Ministers, not parliament. So, Malas, with respect, I say there is no silence. So that was, Malas, just our submission, Malas, on that issue. And then kindly have a look quickly at the Constitution of India for a minute, Malas. Now, if you see, Malas, I'm not going to read the language. Just want to ask your lordships to notice three things. One, there are entire Article 370 has 2 colons. The rest are all semicolons. And the 2 columns reside where, Malas? They reside in D. There's a colon after D. And there is a colon after 3. 370 sub-article 3.
Colon after D?
D, Malas, 37 1D. And colon after 370 sub-article 3. So you cannot exercise that power independent because it's integrated. The process is integrated, and it's only a process that we are talking about. We're not talking about powers here. 370 is only a process of integration. And Miller's Constitution Bench and Manohar mentions that. And we are dealing with the process adopted by the Government of India consistent with this process of integration. We're not talking about anything else, Millers. There is no unilateral notification issued by the Government of India, by the President on the aid and advice of the Council of Ministers that's before you. There is no unilateral declaration. And I'll assume for a moment, Millers, there is a silence. How will your lordships, Millers, integrate that silence into 272 and 273? Because 272 and 273 deals with 370 sub-article 3 as it stands. You will still have to say whether 272, 273 is consistent with the unilateral notification to be issued by the President, which is not there and which is not before you. It's not possible to match the two. It's not possible for you to state constitutionally, Millers, that 370 notification or under sub-article 3 will justify the action taken, which is 272 and 273, which has nothing to do with the notification. If you uphold 272 and 273, you will have to uphold it on its own terms, not on terms other than 270 sub-article 3 and the proviso, because that's what they have adopted. Even if you were to accept that argument, it's not possible for your lordships, with the greatest respect to Millers, uphold the action under 272 and 273. And so I was, Millers, that's one thing I was saying. Now kindly see, Millers, please kindly see. And kindly see the absurdity of this. The absurdity is that when it comes to 371, B1 and 2, you have to consult, or you have to the state has to concur. If it comes to 370, 1D, again you have to consult and or concur. When it comes to 373, you can abrogate without consultation, without concurrence. How can that interpretation ever be accepted by a constitutional court? Means that you don't need consultation, you don't need concurrence. You can unilaterally do it. For everything else, you'll need that. That's a constitutional absurdity. For individual articles, you have to concur, but for the whole abrogation, you don't have to concur. Even for a law, you have to concur, Malad. This is, I give the greatest respect, Malad, at least take the text and the context, Malad, not a pretext. Now, Malad, I just want one other thing. If you look at Article 371, notwithstanding anything in the Constitution, starts with it. Your Article 371A, notwithstanding anything in the Constitution. And then 371A, sub-article 2, notwithstanding anything in the Constitution. Then, Malad's special provision with respect to state of Assam, notwithstanding anything in the Constitution. 371C, notwithstanding anything in the Constitution. The 368 will not apply to any provision of the Constitution in this chapter. Is that not against basic structure? If the argument is, at least I didn't argue the basic structure, but otherwise, that's also against basic structure. Why don't you set aside the entire chapter? Every provision other than one, which relates to Andhra Pradesh, starts with notwithstanding anything in the Constitution. Now, as far as Jammu Kashmir was concerned, they had an added protection, the proviso, to 368. That constitutionally means that the complete merger that we are talking about, dehors the proviso, could never be done. There could be an argument as far as other articles are concerned. You may still apply, you should use 368. You may argue that. To what extent it will be upheld or not is a separate issue, because in some of these articles, even treaties cannot be changed. Some of these articles have treaties, Mullah, between the government of India, which was entered into in the past, cannot be changed. So whether 368 will apply or not, we are not into this. I'm just getting you the scheme, Mullah. So Mullah, I'm done with this.